Hello, my name is Pino Bacinello with Pacific Business Brokers in Vancouver, British Columbia, Canada. We're bringing you business, sales and acquisitions, educational video blogs. Today we're going to talk about what are called legal instruments in the purchase and sale of a business. First, let us understand the meaning of legal instruments. Generally speaking, these are nothing more than legal documents or tools required to solidify and formalize the transaction itself. They really are just tools, and hence the reason they're called instruments. These instruments are documents that state some contractual relationship or that grant some right. Contracts, in essence, are recognized by the courts as legal instruments. The process of purchase and sale of a business often starts with an expression of interest in some form or another. These can vary from a simple indication of interest to a term sheet, a letter of intent, or an offer to purchase. Likely, the very first instrument in the transaction of a small business purchase and sale is an offer to purchase. Such instrument sets out the parameters of the transaction subject and related specific terms and conditions. Generally, the purchaser's lawyer or attorney is responsible for drafting the first official instrument in the purchase and sale of a business, that being the definitive agreement of purchase and sale. The role of the purchaser's lawyer is primarily to draft and assemble the required instruments, while the seller's lawyer's role is one of commenting on the language of the agreement, providing required information to the purchaser's lawyer, and generally assisting his client in minimizing risk exposure and making his client aware, of course, of potential risks and probabilities thereof. Any changes to the offer would typically be documented and agreed to through an amendment, which is an instrument used to make changes to the existing document, or an addendum, which is an instrument used to make additions to the agreement. Other instruments in a purchase and sale of a business could be a training and transition agreement, where the terms and conditions of the post-closing training and transition agreed upon are articulated, a non-compete agreement, where the explicit terms under which the seller may or may not act within specific geographical or time parameters, a promissory note, if the vendor is financing a portion of the purchase price and where the terms and conditions of repayment are identified, a general security agreement or GSA, again, often used where the vendor financing is involved and where it articulates the pledged securities against the repayment of the debt. A premises lease or other operational or capital lease or assignment thereof. Directors and shareholders' resolutions authorizing the sale of the assets or pledge of shares or securities, resignations of the vendor officers or the company and acceptance of the purchaser's officers, certificate of incumbency where an official document lists the names of incumbent individuals or confirming officers of the corporation, certain clearance certificates clearing the vendor of his or her obligations to specific liabilities. Of course, closing certificates where the vendor certifies that as of that closing date, certain instruments and acts will have been delivered and or acted upon. Declarations, possessions, and other such documents as a bill of sales or assignment of contracts. These are all instruments. Knowing this, you will know that there is much work involved in the purchase and sale of a business and many moving parts, and hence should not be considered without the guidance of a professional legal advisor in cooperation, of course, with a professional business broker or intermediary to manage the whole transaction to a successful close.